This basically the same ordinance we had before, which is if you can hear it outside of the vehicle, it's too loud and you can get a fine. But the fine has been raised so that it's $250 for the first violation, $500 for any subsequent violation. On the impoundment issue, now it's based on totally on what the Chicago ordinance is, which is if the officer can hear it 75 feet or more away, they have the discretion to tow it as well.
Captain Tom Magny, Commander of District 3. The Chief has reviewed the ordinance and has authorized me to speak on his behalf today. The way the ordinance is written right now, which gives discretion to the officers and will allow internal procedures in the department to be set up for the towing of vehicles, we support this as it's written.
Impounding that vehicle will send the loudest message, and hopefully we won't have to do that often, but the word will then get out that, hey, the city is serious about this, that they will impound a car if it comes to that. We really don't want to do that, but if it does come to that, we'll do that.
It's up to the police officer to determine what's loud then. Basically.
It has to be, if they can hear it outside of the vehicle, and that's the current law. If you continue to issue the tickets, the difference is there's a higher fine. And if they can hear it 75 feet, we're saying that they have that they can elect to tow. And that's the same as it is in Chicago. First of all, the police officer in the field makes an initial determination. They then actually have that reviewed by the city consular's office because they bring the case on behalf of the city. The officer is only a witness. The city brings the case. And so the city consular's office will review that, and then a judge ultimately makes the determination as to whether there was sufficient evidence to find the person. In addition to that, we have a procedure through the street department that allows the individual, if their car is impounded, to get that vehicle back without even going through a court process.
I think it satisfies some of the concerns that the comptroller had, and that was it would not have anything to do with the size of the speaker and would not impact those businesses that sell them. I just think that the 75 feet thing, if they really got technical, you have to measure it off. I think anytime you play that darn thing loud enough for me to hear it, and I ain't in your car. I think that's wrong.
Does the committee substitute still hold, though, that the car is still impounded before the person is technically found guilty?
It can be, absolutely. Yes, sir. And we have similar circumstances under a different setup for littering, prostitution, towing, illegal towing, working on vehicles, all of that. And the ordinance in Chicago has been found to be reasonable, and so we believe that this is also reasonable.
What do you say to those that fear that this law could be enforced selectively? That is, that it will most likely be enforced on the 18-year-old kid with the big speakers in his car, and not the 45-year-old executive with the factory Lexus that comes equipped with 20 speakers inside that's capable of making the same noise.
I think any law has the potential to be selectively enforced. I think from what I've heard from the community and from law enforcement, they're very concerned about the speakers that are causing the whole car to rattle, to cause people's windows to rattle. And so if somebody has 20 speakers and they're turning it up loud and you just hear it outside of the vehicle about 3 houses down, I suspect those people are going to get a ticket. But if you're having it rattle and it's disruptive to hundreds of people around the neighborhood, I suspect those may be the type of vehicles that could be subject to impoundment.